Welcome to JGL Law for You. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will be discussing a wide array of topics to help you navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. I am very excited today. We are talking about two areas of the law and how they sometimes connect and bleed into each other, personal injury and family law. And to help us talk about that today, we have two lawyers from Joseph Greenwald & Lake. The first, who is her first time here on JGL Law for You, Renee Blocker. Renee is a personal injury lawyer, runs our personal injury department at Joseph Greenwald & Lake. She understands that each and every client's case is unique. She's an experienced trial attorney with a history of advocacy for her clients in the areas of personal injury, premises liability, workers' compensation, and criminal defense. She emphasizes the understanding of each client's goals and objectives. And talking with us, Renee and myself today, welcome back Lindsay Parvis. Lindsay is a shareholder at Joseph Greenwald & Lake, focuses her practice in all areas of family law, and she too is focused on helping her clients navigating some of life's biggest challenges: divorce, custody, domestic violence, financial matters, and more. She makes complex information and advice understandable and manageable. Lindsay's services include attorney representation and advocacy, parenting coordination, and mediation. And we are talking about the collision of personal injury and family law. Welcome, folks. I'm so glad to have you today.
Thank you, David.
Thank you.
Let's start with you, Renee, since you're the newbie here, okay? Tell us a little bit about, when we talk about personal injury case and people getting money as a result of an award, what goes into that award?
Yeah, there's several pieces that are involved in a personal injury settlement. And dividing that up or splitting that up is something that most clients never really deal with. It's mostly done by the attorneys, but it's something that clients should be aware of. And it can be explained to them by their attorneys if they want that information. But the attorneys do go through and they look at the different pieces and they say, how much was spent on your medical bills? How much was actually done to pay off all the bills that you had related to your doctors and your physical therapy and your prescriptions at the pharmacy? And then how much went to transportation, getting back and forth to the doctors? Any medical devices you had to buy, any canes or anything you needed for your neck or your back, all of those things are part of that medical expense. Then they look at what you had in lost wages when you couldn't work, the time that you actually had to miss from work where you weren't able to go to your job, expenses that you would have had you not been able to be there. So they actually take a look at what your wages were prior to the accident, and they'll calculate it with some, obviously with some help from your employer on your actual amount that you earned, and they'll give you a wage amount for that. And then they'll also look at your pain and suffering. Now, this is the one that's a little bit amorphous. It's relative. Pain is a relative number. The first two can be set aside, and you can pretty much get definitive answers on your medical bills and definitive answers on the amount of lost wages. But pain and suffering is relative. It's relative to the person, and it's relative to the injury and the type of claim you have. Also, there is loss of consortium.
What's that?
Loss of consortium is a relationship between a couple. If you have a couple, man or woman, that are in a relationship and there is a loss to the marital consortium, they are not able to spend time together. They are not able to do the marital activities that they would normally do, including sex and life and travel and all of those things that are involved. That's a damage to the marriage, and there is recompense that you can get for that. Those are the four main things that are involved.
All right. Okay. So if I'm hearing you correctly, I used to do personal injury work back in the old days, which I never used to say when I was younger. Now I say the old days all the time. It sounds like there's sort of two buckets. One, in a personal injury case, one are damages that you can actually put numbers on. You can write numbers on a chalkboard, so to speak. And the others are more of a feel kind of thing, more subjective in terms of what the value is. But there's not a specific number necessarily you can put on someone's pain and suffering because they had a broken leg or their neck was hurt or whatever the case may be, right?
That's right, right. There's just
And the same thing, with the loss of consortium, the damage to the relationship. That there's not a real specific number that you can come up with economically.
correct. Those are going to be relative to the individual person and the individual injuries. And
Okay.
every single person's injury is different.
So, Lindsay, why does this have anything to do with what you do?
Well, that's because some parts of a personal injury award are marital property that can be divided in a divorce, and some parts of a personal injury award are non-marital property that can't be divided. And we'll get to how timing may matter on this, but if you have a personal injury that occurred during the marriage and an award was received, you've got to look at these different parts and try to figure out which part. So when I'm talking about, you got to look at these different parts, the things that Renee just talked about, right? Is it payment of past medical bills or past lost wages? Is it pain and suffering, loss of consortium? Also, another category is it for future wages? And in looking at those categories, figuring out where do they fall in the legal buckets that our Maryland law has defined as being either marital or non-marital, because marital property can be divided, non-marital can't.
So let's use a simple example for just a second. Let's say that you've got a married couple and one of the spouses was in an automobile accident, injured as a result of someone else's negligence. And as a result of that, they hired Renee. Renee represented them throughout the course of their treatment with the doctor. And at the end of the day, they recovered $20,000. That was the recovery. And let's just say that's what they netted. Say they netted $20,000. We don't have to get into the counsel fees and all that sort of thing. Say they netted $20,000. How do you know by seeing that they got a check for $20,000 that some portion of that was marital property or some portion of that was non-marital property?
Well, that's a very good question. And it's something that really what you're going to get from the judge is just a number. Sometimes
or a settlement, right? I mean, it's not necessarily a judge. Yeah.
Right. Even a judge might break it down as in medical expenses and pain and suffering. But in a settlement, they're just going to give you a number, a flat out number. But You'll need to talk with your attorney, and your attorney can give you an idea as to what is actual that in that fixed number category for wages and medical expenses and what's in that pain and suffering category.
All right, but hold on a second. Let me go back to Lindsay for a second. Lindsay represents the spouse who wasn't in the automobile accident. All right. Your client's spouse got a check for $20,000 as a result of an automobile accident, they had on June the 1st, whatever year it was. So what are you trying to find out that went in? What are you looking at to try to decide what's marital and what isn't marital as part of that $20,000?
So the categories that fall into that marital bucket are medical expenses that the couple paid during the marriage, lost wages during the marriage, and that can be lost wages of the spouse who was injured, and it could be lost wages of the spouse who wasn't injured but had to perform caregiving responsibilities and had lost time from work from that. And then also the joint claim for loss of consortium. And with those being in the marital bucket, you got to find out from the award what of those, what part of the total $20,000 awarded fall in those categories. Now, future lost wages are not considered marital property. They are non-marital. And it's really a matter of what I'm looking for. Is there documentation or is there some breakdown for what those are? Because as a family attorney, I don't know that. The person who best knows that is the personal injury attorney.
Right. So Renee, when you go to settle someone's case. And you write some sort of a correspondence to the insurance company, right, in order to try to settle that case. And in that correspondence, you include not only, what happened in the accident, right, but also what your claimed damages are, right? Now,
we do. In fact, we do that in detail.
Okay, so, and in that claim for damages, do you include specific numbers for medical bills, for these services that Lindsay referred to? This sort of economic loss, I guess, is what we're talking about, right? Isn't that really what we're talking about, is economic loss? Not real numbers, that chalkboard again?
We do. With the numbers that can be pinned down, we actually do lay it out, doctor by doctor, bill by bill, and the wages, the hours, the rate of pay, or the salary lost. We lay all of that out for the insurance company. And then we also put in a factor for loss of consortium and a factor for pain and suffering. And we factor all of those numbers in together, and we put that in, and it builds a lump sum number that we ask the insurance company for. But that's part of what we do as personal injury attorneys. We do break that down for you, and it can be found in the demand letter.
Okay. So the demand letter is that correspondence that we're talking about that gets sent to the insurance company that sets forth these categories of damages, both that are economic loss and non-economic loss, right? And in that demand letter, let's just hypothetically say that we're using the same couple again, right? That your client had $5,000 in medical bills and other economic loss, $5,000 total in medical bills, lost wages, whatever thing you could actually, prescriptions, and you put an actual number on, right? So now Lindsay gets that letter, and Lindsay sees that her client's spouse recovered $20,000 and reads that letter and sees that you laid out the economic loss of $5,000, yet the client got $20,000. What, if anything, can Lindsay presume from that $20,000, given the fact that there was $5,000 in economic loss?
Well, first of all, the $5,000 in economic loss would be monies that were spent as a couple, would be monies that they spent as a marital couple. So those are automatically marital funds. And that's part of what Lindsay would look at. But the other money, the money that isn't listed as specific with those numbers, that's going to be more towards pain and suffering and loss of consortium. And that's going to be something that's really going to be more on the side where it needs more investigation.
Okay, so Lindsay, let me click back to you for a second. So now you know, because you've gotten this letter, this demand letter that Renee sent out, which resulted in a net recovery of $20,000 to your client's spouse. And you know that of that $20,000, $5,000 is economic loss. So you know that $5,000 is marital property based on what you told us before, right?
It sure is, if it still exists.
Tell us a little bit about that. Tell us what you mean about that.
Sure. So let's say this $5,000, part of a $20,000 award, is received during the marriage. You've got to then look at not only what categories it fell in, but where did it go? Where was it deposited? Does it still exist? So was it deposited into a savings account and it was never used and it was intended to be there for if and when they ever needed it? Great. Then it still exists and there's been no activity. It's really easy to figure out, plus the interest that might have accrued, what the parts are. But if it's deposited into an account, and this is probably true of most people, if it's deposited into an account where their paychecks are also deposited, where they're paying bills, then you get into problem area in family law that we call commingling, where this PI award is getting mixed up with money that is earned during the marriage and money that's getting spent on bills, and you can't separate it out anymore. And at that point, if it's been spent, it's gone. If you kept a balance in the account from the time it was deposited up until the present, you're still going to have problems proving whether $1 in there is from the personal injury award or $1 is in there is what's from wages. So you can have that commingling. And when you've got commingled property, it's considered marital under the law. And then you can have a piece where you may have received the money, and let's say it's a big award. I'm not talking $20,000, much bigger award. People may have invested it. And if they've invested it and there's been a lot of activity in that account, buying and selling investments and reinvesting and having some money come off of that, you can also end up in a place of, can we still identify that personal injury award as a separate thing? And can we still identify the separate parts of it? Or just, even though there's no money that's really gone in, because of the activity and how it was invested and moved around within the account, is it then commingled and marital? Yeah.
Okay. All right. So now let's talk about the other 15. Go back to our example for a second. 5,000 is potentially marital based upon what may have happened to it. But now we've got this other $15,000 that is non-economic, right?
Right.
How do you try to figure out? Because Renee is not going to help you. Renee represented your client's spouse. She's been told not to talk to you. So you've got this letter. You know how much your client's spouse got. How are you going to try to, and setting aside what happens to it later, set aside the potential for commingling and all that. How do you try to figure out how much more of that that other $15,000, can you pull into a marital pot?
Well, first, I really do try to figure out whether or not the personal injury attorney only represented the other spouse or if they represented both, because you have these joint claims, right? Joint loss of consortium is just one example. So that attorney may have represented both, and you may have access to their file, if it still exists, to be able to see what the parts of the award were. So if not from the personal injury attorney, then it's going back to my own client's files and what exists and trying to find out what documents they kept about it to try to figure out what the different parts were. And if not there, if the case was litigated in court and went to trial, trying to find out what the court file has to say about it. There's a lot of investigation that goes on to try to just figure out, do any documents still exist? What do those documents say? And if we don't have documents that say what that remaining award was, right? That remaining $15,000 that I think here we're really talking about as being loss of consortium and
pain and suffering.
And pain and suffering, then really it's up to, just going back to our example where I'm representing the non-injured spouse, it's really up to the injured spouse to have to show and prove what the non-marital portion is, right? But if I were representing the injured spouse, oh boy, would I want to get those documents and do my very best to try to prove what the non-marital part is. Because if I can't show that it's non-marital, if I can't show what part of it is, directly traceable to my client's claim and their non-marital property, I'm facing being out of luck and having that personal injury award all being treated as marital.
In its entirety, you mean?
Yeah.
Right. So Renee, when you try a case and the case goes to the jury, they get a verdict sheet, right?
Correct.
And in a personal injury case, on that verdict sheet, are they asked to break down how much do you award plaintiff X for the different categories, loss of income, pain and suffering, loss of consortium?
They are asked to break that down because you have different parties. If a case was going to suit and it was just one of the spouses, not everybody claims loss of consortium. So if it is just one party, he would go to court or she would go to court and they'd be claiming their own pain and suffering, their own medical wages. And then part of that would be marital, part of that would be non-marital. But if they go to court, they file a joint claim, the jury would then break it down as what is loss of consortium between the couple and what is going to him individually or her individually for his or her pain and suffering and the lost wages and the medical expenses.
All right. So in that case, if Lindsay were able to get a hold of the verdict sheet in our hypothetical case, and again, we just use this $20,000. I understand things come in and out of there. Just use the 20 grand as that's what the client got. But as part of the verdict sheet, the jury awarded 0 for loss of consortium. That would cause Lindsay some problems, right, in terms of using that portion of the verdict as a marital property component, right?
Yes, it would. She would then have to go back and, because the jury obviously found that there wasn't a loss of consortium claim or that the spouse wasn't due loss of consortium money based upon whatever evidence they heard at the trial.
All right, so now let me ask you a different question. We've worked this $20,000 case to death. Let me ask you another question. So I come to you. I was hurt badly in that. It's a significant damages case. Whatever it was, my injuries were bad, my loss of income was bad, and it's clear that the other party is at fault. Let's just use automobile accident because it's simple. Everybody knows, everybody sees those all the time. You say to me in our initial interview, you married? And I say, yes. And you say, well, let's get your spouse in so we can include your spouse. And I say, no. I don't want my spouse involved. I don't want any loss of consortium because I've talked to my divorce lawyer, Lindsay, who tells me I don't want to include loss of consortium in this claim. Now, I just want to be your plaintiff. What do you do?
I caution my client straight out.
Meaning what?
And I tell them, you have to understand, you can try to, if you're thinking about divorce, if you're contemplating divorce, you can only protect yourself so much from that giving your spouse money. Spouse is entitled to a portion of your settlement. The portion that, and I would explain to them that the portion that came from marital property, meaning loss of wages, medical bills that were paid for marital expenses, that's going to be split. And
okay. But let me cut you off, Renee. I hear you. But my lawyer, Lindsay Parvis, told me specifically that I should not include a loss of consortium claim. It's not your job to worry about what's marital or what isn't. Your job is to help me get the most money I can get. And I'm telling you that as part of my claim, I don't want that included. So then what do?
You don't have to. You don't have to.
Okay. So Lindsay, in that circumstance, let's flip it around. Your client comes to you, you know that a person was in an automobile accident, you know that they're in the process of retaining counsel. What, if any, discussion do you have with them about including or not including the loss of consortium claim? It's a big case. There's potential money that's going to be split. What do you tell your client about how this personal injury case might affect what might happen in terms of a settlement or in terms of what a court does?
In meeting with my injured client who's pursuing a personal injury claim, I would talk them through the marital and non-marital property parts of it in the way I've talked about it here. I would also talk through the importance of having documentation of the award, however an award's decided through settlement or a verdict, that breaks down the award as much as possible. I would talk with them about whatever awards that is received, that goes in its own separate, segregated account, and that there's no other money that's deposited in there, so we can try to keep it separate and maybe even break it up into its component parts, right? Break it up into the medical part. If there's a medical expense reimbursement component to them versus medical bills that are withheld to just be paid directly to providers. Break it up into the lost wages. If we were to have a breakdown on, say, pain and suffering or any other sort of more amorphous ones, have a separate account for that. Okay. But on the part about their spouse, right? If part of my injured client's question is can I just cut my spouse out of participating in the court case? Well, one, I'd want to consult with their personal injury lawyer about that. But two, there is, when it comes to loss of consortium claims, right? And this is one of these claims that both spouses bring. So both spouses have to participate in that claim. And is considered marital property. I would talk through with my client the possibility, one, that claim cannot be brought at all if my client won't participate in it, but that there may be some other claims that their spouse could individually raise as part of the suit and maybe become a party in the suit if, for example, the non-injured spouse lost wages because of being a caregiver. So it wouldn't be quite as neat and clean as I don't want my spouse to participate. So that decision is made and the spouse never participates. Never mind, their spouse may also be a witness and be brought in to testify about different things. Not so easy to do this in a completely cut off, siloed way.
Yeah, and loss of consortium, right, can vary, and I'll ask you both, depending upon what exactly the damage to the relationship was as a result of the injury, right? I mean, so if you have a situation, Renee, where you've got this client who comes in and they've been separated for a year and a half, 2 years, they're not lived together, they haven't been intimate, they haven't done things together, the value of that loss of consortium claim might not have any value at all because they didn't lose anything, right? So I suppose that both of you, if you're both talking about this joint client, that you're going to be looking at that, right, in terms of is there value, and if so, how do I protect my client?
Well, I would, of course, obviously, we do ask the question, are you married? All of those things are part of the intake. And I do ask the questions, are you separated? Because there is, as Lindsay has said, potential that money is due to the other spouse for portions of the actual recovery that she or he did put in to pay for expenses that were lost during the treatment and the recovery. So I would definitely want to ask my client, what did you lose to the marital relationship? What was the loss? What type of things were lost? Was it fellowship? Was it time together? Was it the intimacy? Or have you been separated and you really haven't lived together? You haven't had that fellowship. You haven't had that intimacy time together. And the only losses might just be something economical, that because you still had the same bank accounts, it was economic. So I would discuss that.
And Lindsay, those of us who do this work, we've had cases, and I know you have, where you have a client who comes to you and might say something along the lines of, everything was terrific. We were doing fine until this bike injury, when he got hit when he was on his bike and got hit. And then all of a sudden, he suffered a traumatic brain injury and the whole marriage, things changed, right? I mean, you've seen cases or had clients with that kind of a story.
Yes, I have. Mm-hmm.
And in that case, you would look strongly at this, at the aspect of this loss of consortium piece to the personal injury claim, for whether you're representing either side, right?
Of course, I would look carefully at it, and timing is an important piece, right? So if the client is coming to me when the personal injury claim is all over, said and done, the money's been received, that's a different conversation focused on, do we have a breakdown of the money received? Where was it deposited and how has it been used? So can we tease it out into the marital and non-marital components? If it's an ongoing claim, right? So this is someone who maybe hasn't yet sent out a demand or is thinking about doing it and just everything has fallen apart, but they haven't done anything to pursue their personal injury claim, then it's a matter of coordinating with personal injury counsel for them to try to work on the best approach, and bearing in mind and being realistic about when it comes to the family case, or maybe this is just my thinking, when it comes to these awards and how much is being pursued, the cost benefit on trying to pursue the award, what is likely to be recovered, what is realistic, and how does that then impact the family case, and sort of the cost benefit of what it is to be fighting about that in the family case or not. So there's some complex conversations that have to be had with clients as they are the decision makers on what paths they are going to pursue.
Well, I have like 50 more questions to ask, so we're going to have to do a part 2 to this. I think the moral to this whole story, the last 30 minutes or so, is you got to talk to a lawyer. Lawyers are there for a reason. If you're in an automobile accident, you talk to a lawyer. If you've got in a family situation, you got to talk to a lawyer. Renee, if people want to get hold of you, what's the best way to reach you?
Sure. I'm at the Greenbelt office for Joseph Greenwald and Lake, and they can reach me at my direct line at 240-553-1106. My email is at rblocker@jgllaw.com, and I'm available. We'll take emails if questions and any things that you might have, concerns, and would happy to be taking a phone call with an intake and be able to help you if it's warranted, if it's something that you need.
Awesome. Thank you. And Lindsay?
I mainly work out of our Rockville office and can be reached at 240-399-7900.
All right. Well, thank you both for coming on. Folks, we hope you enjoyed this time. We look forward to having you back. And this is JGL Law for You.